4 South, booth 1. Come back inside unless you're getting meds. 5 North, get back in here. Get back in the booth. Get back in the booth. Get back in the booth. All right, go ahead, Miss Rhonda. Sorry, everybody.
That's all right. Since Mr. Horn has been in custody for over 90 days, he is entitled to a bond. For charge 1, the seatbelt violation, I would ask for a UJR. And for the rest of the charges, I would ask for bond not to exceed $25,000.
Miss Rhonda, there was a probation violation as of 11/21/22. Has that already been taken care of?
Oh, I was not aware of that.
It's on wait, hold on a second. Hold on. Maybe I just called the wrong one. Hold on. Yeah, I'm sorry. No, it's the armed robbery that was a warrant issued. So there's a warrant out there for an armed robbery. Do you know about that?
I was not aware. Is it out of Fulton?
It's got a 278715 MC. That's all I can see on as of April the 23rd, 2008. That's all I can see on Odyssey.
2008?
It said it was issued 4/23/2008.
Okay.
Yeah, but that's, I don't know if it just says Magistrate Warrant Central, but the warrant number is 278715 MC.
Okay.
So they
I will be looking into that.
All right. What says the state?
Judge, breaking with my long-standing tradition, the state is going to recommend for the seatbelt violation a $1,000 bond, for the possession of a firearm during the commission of a felony, a $10,000 bond, for the receipt of a firearm by a convicted felon, a $15,000 bond. State's going to request a $1,000 bond on the 2 violations of the Georgia Controlled Substances Act charges, a $5,000 bond on the theft by receiving stolen property, and a $500 bond on the tampering with evidence.
You said 1,000 on the 121 grams of weed.
Yep.
You feeling okay?
Judge,
Just checking.
that reflects the likelihood the state will be able to successfully proceed against the defendant on that charge.
Just making sure he was feeling okay. I think Ms. Rhonda was thinking the same thing. All right. I'm going to do UJR on the seatbelt violation, 10,000 on each count of a firearm. So possession of the firearm and the receipt or a firearm, 10,000 on those. And then per the DA on the 2 possession charges, 1,000 on each, 5,000 on the theft by receiving stolen property, and 500 on tampering with evidence. No drugs unless prescribed, no alcohol, no weapons, no further contact with Renee Torres, Torress, no further contact with your co-defendant, Tupac O'Neill, TUPAC. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment, as long as you supply the name of your employer, proof of employment, the location you're going to be working, and a schedule. You have to supply that all the each time you get a schedule to Miss Rondon. I did know there was a probation violation in 11/21 by Judge McBurney. So I'm assuming you handled that. I did have that note written down here. If you want employment, you got to provide all that stuff about your employer to be able to do that. Best of luck to you, sir. You can leave the booth. See, do I have Andre Blanks? All right. Sorry, folks. Pollen's horrible. All right, Mr. Law. Position 13. 12. 22 CP 214345. Andre Banks. 111 days without indictment. There's a $16,000 good bond as of December the 1st. Possession of firearm by a convicted felon, pedestrian in roadway, and misdemeanor obstruction. Pre-trial.
In regards to Mr. Blanks, 10 prior arrests, 2011 burglary out of Springfield. Nothing further.
All right, go ahead, Mr. Law. And is he still planning on living in Springfield, Mass?
Let's see. Yeah, all of his addresses he has are in Massachusetts, but he does say he does have an address that he can live at outside of the jail at 1339 Andrews Street, Atlanta, Georgia, which is owned by Marcus Dyer, one of his friends.
Not going back to the birthplace of basketball, Springfield, Mass.
Well, it's North Carolina's better for basketball anyway.
Yeah, it is. That's the birthplace of basketball. Go ahead.
Mr. Blanks is age 32. He moved down here in November to find a new job and meet some of his friends here in Atlanta. All of his family is up in Massachusetts. He graduated from high school in 2010 at Springfield Academy, and he's forklift certified and has started on an HVAC certification, but hasn't completed it yet. He is still looking for work and plans to work once he is released from the jail. So he's just looking to get out, looking to restart his life and get a job here. And we're requesting $5,000 so we can get a bail project bond for him.
Wait, what says the state?
Judge, the state notes that this defendant has a $16,000 bond. There has been no compelling argument to reduce the amount of the bond, and the state would object to any reduction in the bond.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 160 Ponce de Leon Boulevard. Let's see, $15,100 and then $250. $15,100 and then $250. Best of luck to you, sir. Right, I got Lena Lewis. All right, Mr. Laws, this is you too. It's 11/22 CP 210316. 263 days without indictment. As of July the 1st, there is a $164,500 good bond on trafficking methamphetamine, trafficking cocaine, trafficking marijuana, BGCSA, possession of controlled substance in Schedule 1 or 2 with intent to distribute, possession of firearm during the commission of a felony, possession of cocaine, possession of marijuana with intent to distribute, possession of dangerous drug, possession of dangerous drug. Pre-trial.
Which defendant, Judge?
Lena Lewis.
Who? Which number?
11, Lena Lewis. That's why you shouldn't take days off, Boston.
I know. Extensive arrest history, 39 prior arrests, at least 3 felonies, a few arrests for probation violations, misdemeanors, a couple of FTAs, prior convictions for armed robbery, ag assault, false imprisonment, firearm by a convicted felon, firearm during purchase, possession, and manufacturing sale. Nothing further.
And what we got here, Mr. Law, just since I've read that up, 263.8 grams of meth, allegedly 31.75 grams of crack, 40.23 pounds of weed, 2.6 ounces of shrooms, 2 grams of coke, and 133 bottles of alleged liquid THC. All of that is alleged. Go ahead, Mr. Lyles.
Yes, Miss Lewis is age 26. She was born in New York, but she's lived here for the last since 2008, so about 15 years. Her father, her son, and her sisters all live in the area, including her son, who's 10 years old, lives with her father at the moment here in Atlanta, and she was hoping to return back to him to take care of him. She has gone through the 12th grade and was working at her GED at Atlanta Tech and doing cosmetology school as well before she was arrested. And she was working at Atlanta Peach Movers doing packing and moving businesses and homes, and she can't return to that job. She was working at her stepmom's church, helping with feeding homeless, and her father is an ordained minister who's also helping with him with his church's volunteer activities. Her sister owns her own home in McDonough, so she has good community ties, though she would be living with her father in Atlanta at 934 Garden Walk Boulevard. So she would need to be able to stay in Fulton County. She does have some medical issues, including asthma and clotting, that are best addressed outside of the jail, and does have MH issues that are, again, also best addressed outside of the jail. She'd like to return to her kid, trying to help get him through his school and go back to school herself. So we are requesting, given that it's been almost a year since she was arrested in July, a 50% reduction to around $80,000.
So why can't she live in Henry County?
Which address is that?
With the McDonough County? Why can't she live down in McDonough?
I haven't spoken to her sister, and so I don't know if she'd be allowed to live there or not, with her sister's permission.
And some of Garden Walk is in Clayton County. So you're in the Garden Walk in Fulton County, ma'am? Yes, thumbs up or thumbs down? Thumbs up. Is it Fulton? Yes. All right, what says the state?
Judge, the state notes that this is 40 pounds of THC edibles, 39.83. And this defendant's GCIC, she's very likely to reoffend when she's finally released from confinement. The state heard no compelling reason to alter the bond as exists. The state would object to any change in the bond.
No drugs unless prescribed, no alcohol, no weapons. Stay away from 850 Oak Street Southwest in Atlanta, Georgia. Can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical. No further contact with your co-defendant, Banlen, Banlen, last name Preston, Preston. Guess employment, as long as you can supply proof of employment, name of your employer, schedule, and the location, but you're not going to work past 9 p.m. Let's see. Count 1, 40,000. Count 2, 20,000. Count 3, 20,000. Count 4, 3,000. Count 5, 10,000. Count 6, 4,000. Count 7, 20,000. Count 8. Best of luck to you, ma'am. All right, I got Shandila McKnight.
Robert Booker here on Ms. McKnight's behalf, Judge.
All right, thank you. 1922 CP 214672, 96 days without indictment. As of December the 15th, there's no bond on aggravated battery. Pre-trial.
Just a second, Judge. That's
No more days off. No more days off, plastic. No more.
no. I pulled out the wrong calendar. She was number 1 on my calendar from this morning. Sir, Mr. Booker, she
Yes.
reset, I think, for April the 3rd, if she didn't tell you, because she had prelim this morning.
Yeah, I heard. I
Okay.
talked to Judge Dallas's office.
Okay, sir. 20 prior arrests, 3 arrests for probation violations, 3 misdemeanors, 2017 simple battery, family violence, FTA 2017. No prior felony convictions, took a first offender on robbery in 05. Nothing further.
Go ahead, Mr. Booker, and tell me where she's going to live.
All right, Judge, she's 36 years old. She's a mother of 4, born and raised here in Atlanta. On the call would be her mom, several of her sisters and brothers and other family. If the court grants her bond, which I think she's legally entitled, she resides at 605 Cedar Avenue Northwest. That's in Atlanta, 30318. She has 3 minor children that are enrolled locally in school, as well as an older child, I believe, that's in college. They are very desirous of her being able to get back out on bond. I don't know if the court wants me to get into the facts of, or the alleged facts, but I think for purpose of the case, she's entitled to a bond under 17,750.
All right, what says the state? Any contact with the victim?
Checking, Judge.
While he's checking, Judge, the victim has reached out. I've given and I hate to call him victim, but the victim, quote, I've given him an email address for ADA Lamar Rhodes and someone else in their office. He's also spoke to the victim advocate. I can say as an officer of the court, he is very supportive of her getting a bond. Whether you want contact or not, I don't know, but he's very supportive of it.
Judge, it does appear that we have had contact with the victim, and it looks like his current position is, we'll just say, at odds from the facts as alleged in the police report. How's that? Your Honor, because of the nature of this offense, the state would request that as a condition of the bond, there be no contact between this defendant and the alleged victim, nothing further.
Mr. Booker, were they living together? Because it happened at 605 Cedar Avenue.
They were living together, Judge, but it was her residence. So there would be no reason for him to have contact with her, for him to come back there.
Okay, Is he still there?
Not that I'm aware of, Judge. I've had contact with him. I do not believe he still resides there.
All right, no
No.
drugs. No drugs unless prescribed, no alcohol, no weapons, no further contact with
It's Jamon Moore.
JARMANMOORE. Ma'am,
That's
if he happens to be at 605 Cedar Avenue Northwest, you can't go there. So if he's hanging out there for whatever reason, you can't go there. I'm just letting you know, okay?
Yes, Your Honor.
Looks like there was 22 stitches allegedly in his face. You're gonna have an ankle monitor paid for by the county, that 24-hour curfew, court, lawyer, medical, and employment, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you're gonna be working. Mr. White, did you give me a number?
I did not.
He's thinking 10,000, Judge, or less.
Sit down, 5 North Booth 3.
Judge, you know, all my numbers end in at least 5 zeros.
Okay. I'm asking for 10,000 or less, Judge.
All right, we'll give her a $20,000 good bond. Best of luck to you, ma'am.
Thank you, Judge.
All right. Let's see, I got Nadeja Greer. Or Gear.
Good evening, Your Honor. Jay App for Ms. Geyer.
All right, Geyer. Okay, so
Close
20
enough.
23 CP 215618. 58 days without indictment, criminal damage to property, second degree, arson, first degree, interference with government property, felony, domestic terrorism, pedestrian roadway, willful obstruction of a law enforcement officer, misdemeanor, riot, unlawful assembly. Looks like this is one of those people at Cup City,
Well, technically, it was
allegedly. Gotcha.
allegedly it was a protest downtown, but yes, regarding that.
All right, Bostic, go ahead.
No prior arrest.
All right, go ahead, Mr. App.
Your Honor, my client is 24 years old. She has lived her whole, you heard she has no priors. She has lived her whole life at the same address in Nashville, Tennessee with her parents. Her mom, her dad, her grandmother, even her fiance are watching via live stream. They're all here in support of her. If granted bond, Your Honor, she can reside with her grandmother who has lived for decades at the same address in Carrollton, Georgia, in Carroll County. That address is 155 Hillside Drive, Carrollton, 30116. As I indicated, she grew up and was raised in Nashville. She has a Bachelor of Science degree in biology from University of Chattanooga. She graduated in May. She's also an award-winning concert cellist. She's classically trained. She'd only been in Atlanta for 3 weeks at the time of this incident. She was here with her fiance, who is a co-defendant in the case, Your Honor. She has, since the time of her arrest, Judge cooperated with police and continues to do so. I have had conversations with Ken Hutcherson, who is the supervisor in the DA's office about this case and about her cooperation. Her father, who is on the, who will ensure, be posting her bond and ensure that she returns to court. In addition to her grandmother, her father, who has fully retained me for the case, is the vice president of a large technology company based in Nashville. She's got zero criminal history. She's not a flight risk, Your Honor. We're happy to have her on GPS, house arrest, ankle monitor, no drugs, no alcohol, no guns. She can stay outside of Fulton County. She meets all of the IOLTA factors. Your Honor, in the police, I realize the charges are serious, but if you read the police report, which I have, we obtained a copy of it. Officer Darian Tabor, Officer Tabor arrests her. And in the content of the report, it says that she was blocking the roadway during a protest. She refused to put her hands behind her back, which led to the obstruction charge. She's wearing all black. She's got gloves and goggles to avoid getting, I guess, tear gas. But after she's in the police car, after she's already under arrest, that is when the arson occurs. And the police officer notes that in his report, that others lit an APD car on fire. And Ms. Geyer had nothing directly to do with that. She was already in custody at the time the domestic terrorism and arson technically occurred. I do want to note that for purposes of bond, because she was already under arrest at the time of the most serious incident in this case. Given her lack of history, her education, her ties to Carroll County where she can stay, we would ask the court for a reasonable bond in this matter.
Mr. White,
Judge, the state notes that 155 Hillside Drive appears to be a vacant lot.
Why does Manning got to be right next
Sorry,
to me?
what? I may have written that
It
down.
appears to be a vacant lot.
No, it's 150. My handwriting's bad. It might be 150 Hillside Drive in Carrollton. Her grandmother's on the Zoom. Her grandmother's name is
I'm back.
Corinne Taylor, and she's lived there for many, many years.
What did I miss? Thank you, Sean.
Hang on
again.
1 second. I'll get the. I
Sean
have
is the
the
best
address
tech
in a
guy
text, Your Honor. So
around.
if Your Honor can bear with me,
My man.
I may have miswritten.
With 3 South, sit down.
I apologize, Your Honor. It's 15 Hillside Drive in Carrollton, Georgia.
They got to get
15
Manning out of that bottom corner. She's got to
South
be right in the
Hillside
middle.
Drive. 15 South Hillside Drive. 15 South Hillside Drive, Carrollton, Georgia. 30116.
Judge, this defendant has been in the custody of Fulton County Jail for 55 days.
58 days.
58 days, I apologize. My math is bad. For 58 days, we've heard nothing from this presentation to show that there's any change in
Poor Manning,
circumstance
get
or
on
any
the
compelling
screen,
reason
Manning.
to alter the bond at this point. Judge, the
There's no
fact
bond.
that the defendant may have a defense certainly is something that may be raised at trial, but is certainly not an appropriate consideration for altering the bond at this time. The state does object to any change in the bond status for this defendant at this time, nothing further.
Your Honor, respectfully, this is the first time we've asked for bond, so we're not asking for a modification or a renewed bond motion. This is the first chance we've had to argue bond.
Sorry, she's reading the domestic terrorism.
So,
Thank you. Domestic terrorism, any felony or violation of attempt to commit a felony violation of the laws of the state, which as a part of a single unlawful act or a series of unlawful acts, which are interrelated, distinguishing characteristics and intended to cause serious bodily harm, kill an individual or a group of individuals, disable, destroy critical infrastructure, a state or government facility, a public transportation system, such as disability, or destruction results in major economic losses intended to intimidate civilian population of this state or any other political subdivision, alter, change, coerce policy of the government of this state or any political subdivision, affect the conduct of the government of this state or any of its political subdivisions by use of destructive devices, assassination, or kidnapping. Blah, 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 keeps going on and on and on. What are have any of the other people that have been there got any kind of bond?
Yes, Your Honor, a couple of them have gotten bonds. I believe at the first appearance, one of them got a bond due to a health condition, but I believe I'm fortunately, the only other case to have gotten to a point where we're requesting bond. But I understand the nature of the charge sounds serious, Your Honor, but if you read the police report, the facts are she's wearing black, she's protesting in the street, she does obstruct, she refuses to put her hands behind her back, but the officer notes in his report that the domestic terrorism, or what constitutes the arson and domestic terrorism, happens after she's already in custody. Now, they may be alleging she's a party to the crime, I understand that, but the police report's very clear that she's already in the back of the patrol car at the time that the alleged domestic terrorism occurs. I think the state's theory is that she was a party to the crime and there with a group in concert with them, and I understand that. However, as I've indicated in conversations with Mr. Hutcherson, my client's willing to cooperate with the state, and she's got no criminal history of any kind. She's college educated. certainly got a place in Georgia to stay on house arrest. I think a reasonable bond is appropriate.
Is her boyfriend, Gary, Graham?
So no, her fiance, Your Honor, is Ivan Ferguson, who is a co-defendant. If the court were, they have prior to this incident, and he was granted bond, by the way, Your Honor. And as a condition of his bond, he was given bond. As a condition of his bond, he was allowed specifically in his bond to have contact with Ms. Geyer because they have a wedding planned and their parents are actively trying to plan their wedding date, which is set. If the court would grant bond, I would ask the court to allow her to have contact for that purpose only, not to discuss the case with her fiance. But more important, Your Honor, is, and certainly the reason we're here today, is to see if the court would grant a reasonable bond. I will say, you know, the police reports demonstrate there was not a single injury in this case. A APD car was set on fire, but it was after my client was placed in custody. That's the act of domestic terrorism that's being alleged.
Anything else, Mr. White? 'Cause I'm pulling up these other co-defendants. Looks like they have 150,000 on the domestic terrorism and criminal damage to property. And
Mr. Ferguson has a, I think it's an aggregate bond, if I recall, of 355,000. And I believe there was one other that got bond at first appearance. I think the others are in no bond status,
And Your Honor, just humbly,
if I recall. And I believe that Judge Locke's decision was based on who had significant ties to the community and who did not. And I believe, yeah, the other one who got a bond was Mr. Avat, who also got a $355,000 bond. Judge, given this defendant's lack of any realistic ties to the community, given the very serious nature of this and the fact that this act was certainly intended as an act of terrorism, both for the public and to influence government policy. The state, as I said, is opposed to bond. Certainly she's not entitled to bond as a matter of right. And there has been nothing presented to disturb Judge Locke's finding of no bond at this point. Understanding that, you know, she may have facts that she can raise as a defense at trial. This is not the time to do that.
well, you know, I haven't heard a single fact of terrorism that's been proffered by the state, Your Honor. If the state knows of any evidence that my client committed arson or terrorism, generally speaking, they're thrilled to proffer that. But the problem is the police officer made it very clear in his report that my client was already in custody at the time those acts occurred. What she is alleged to have done in the police report is refused to put her hands behind her back and refused to get out of the roadway. You know, Your Honor's well aware, murder clients sometimes get bond in Fulton County.
Right.
I understand that she's charged with something very serious, but the facts, if you actually look at them, don't paint a picture that she herself committed serious crimes. Her co-defendants may have, but she did not. And I'm asking the court to judge her based on the IOLTA factors as they pertain to her, not her co-defendants. And quite frankly, she does have ties to the community because her grandmother, who's lived in the same house for decades, owns that home in Carroll County, and she can stay there.
Right, so I'm looking at this other one where Judge Barwick did a couple things with it, and looks like he didn't have a history. Let's, well, it was supposed to be printing here for me. No drugs unless prescribed, no alcohol, no weapons, no further contact with Madeline, last name Feola, that's a co-defendant, or Emily Murphy, that's a co-defendant. Graham Evans, you say that's not or fiance, right?
Correct.
Or Francis Carroll, Carroll. Stay away from 17 Andrew Young International Boulevard. Stay away from the Deloitte building. Stay away from Cop City. You're gonna have an ankle monitor paid for by you with a 24-hour curfew, court, lawyer,
Making her pay for it.
medical. You're gonna have to live at your grandmother's in Carroll County. Stay out of Fulton County, unless you're here for court or to see your lawyer, and you'd be able to avoid Andrew Young International Boulevard when you come here. You don't have to go that way. You can still have contact with your fiance, but I wouldn't discuss the case. I think that's going to be argued against by Mr. Apton, whoever your fiance's attorney is. Anything that your parents or your grandparents have to come out of pocket to pay for you to get bond, to bond you out, or to pay for that ankle monitor, you're going to have to pay them back. Money or sweat equity, either one, ma'am. This is a you problem. It's not your parents' problem. So you're going to have to pay them back. You can cello the heck out of that thing or whatever you do, but you're going to have to make money and pay them back. All right?
Welcome,
Get this
Kendall.
one up here because I wanted to kind of make it mirror that one. Because this criminal damage to property is where they're talking about the car. One second. Sorry, it's being a little bit slow right now. Come on, come on, come on, come on.
Manning's a little off tonight. What do you think? Manning's a little off. I think she knows we're live. The
Yeah,
heat's
the state
on.
inquires to who the person in 2 North is communicating with.
Sorry, one more time, Mr. White.
Due North, who you talking to?
Sorry, Sarge.
Put him in the waiting room till I call his name.
Oh,
He can wait in the waiting room.
Damn
Put
it.
2 North in the waiting room.
am I too north? All right, I'm good.
There you go. He can sit in there and communicate with himself.
I'm gonna move to 4. I'm gonna move to 4N.
Just one second, ma'am. It's just slow pulling up here. Let me make sure this one comes up because I wanted to mirror this one.
And sorry, Your Honor, while you're doing that, you said she can leave for lawyer, medical, and court only, correct?
Right. And stay out of Fulton County unless she's here for court or to see her lawyer.
Yes, there it is.
But you know, don't go into what the Cop City's kind of DeKalb County. Don't go anywhere near Cop City or any other. Don't participate in any of that. Don't go over there anymore. I'm not real sure why people from out of state come down here. That just is amazing to me. Hold on. There it is. All right. Sorry, I was looking for this one so I could make it mirror this. Is she gonna have a job in Carroll County, or is she
No,
just
Your
gonna?
Honor, she's gonna be on 24-hour house arrest except for lawyer, medical, court.
But if she's able to find a job later, just email me, Mr. Apt, and I will modify it because I mean I
Thanks,
don't want her to
kids.
mooch off her grandmother.
Okay.
But we'll modify it to add that.
Little pre-trial
Right, come
juice.
on, this is slow. Why is this going up? Damn it. Sorry. Come on.
Oh, she's dying with that computer. It's killing her. Oh, this is killing her. We could go to clips. I got clips loaded up, and we could go back to Manning, back and
Oh,
forth.
it's Graham EVATT. Is it Evans or EVAT?
It's EVAT, Your Honor.
Okay, EVATT, Ms. Hunter. Hold on one second. There's so many co-defendants, one of them's finally coming up.
Oh, Manning's dying with this computer. Look at her. Poor thing. See, but she can't go to clips like us.
There it is. So we'll make it model this one. I'll make it model this one with 10,000 on count 1, 100,000 on count 2, 20,000 on count 3, 150,000 on count 4, pedestrian and roadway, UJR through the jail. Because this said pretrial, but that's reporting in person. I don't want her in Fulton County. 20,000 on the obstruction. Wait a minute, that's 6. Wait, hold on. Oh, the obstruction, we'll make that 3,000, 20,000 on the riot, and 5,000 on the last one. 10,000, 100,000, 20,000, 150,000. UJR jail, 3,000, 20,000, and 5,000. Got that, Miss Hunter?
Yes.
All right. Best of luck to you, ma'am. Good to see you, Mr. Rapp. Like I said, if something changed, just email us.
I'm just trying to add that up real quick, Your Honors. The total bond is
10,000, 100,000, 20,000, 150,000. UJR through the jail, 3,000, 20,000, 5,000.
308,000 total bond.
Yeah, it's 620, Sean.
I got.
But she didn't have any hearings today, though, right? I didn't see her pop up.
All right. Best of luck to you, ma'am.
And Your Honor, that's cash, property, or surety, correct?
Right.
Good bond. Thank you, Your Honor.
Thank you. That it for the ACDC, or to have another female?
That's it, Your Honor. Thank you.
Have a good one. William Rhodes. All right, Mr. Rhodes, this is number 4. I think you got 2 cases, Ms. Rondon.
Yes,
22
Your
CP,
Honor.
22 CP 214197, 123 days without indictment. No bond as of November the 25th. Criminal damage to property, 2nd degree. Burglary, 2nd degree. Possession of tools for a crime. 22 CP 214060. 123 days without indictment. There is a $20,500 good bond as of November the 18th. Possession or control of a substance in Schedule 1 or 2. Possession of tools for a crime. Criminal damage to property, 2nd degree. Burglary, 2nd degree. And possession of drug-related objects. Pre-trial.
That was a weak pre-trial, Manning. Oh, weak. Judge. ¿Qué pasó?
What'd you say, Bossy?
I wish I could, Sarah. I
Yeah,
actually used
Rhodes.
22. I looked up
32
silent.
prior arrests,
clicking
at least
mice.
4 felonies, open case 22, CP 214. Nope, that's the other one. 4 misdemeanors, 3 felon,
I swear it was
4
on my
arrests for
Amazon.
probation violation.
Quiet,
Open case
clicking
also
mice.
for driving with a suspended license and drug-related objects. Nothing further.
It
All right.
annoys me
Go
so
ahead, Miss
much.
Rhonda.
All right, Mr. Rhodes is 45 years old. He is from Villa Rica, Georgia, and that is the address that he would be able to stay at. It is 55 Tyson Court, Villa Rica, Georgia, 30180, where he would live with his wife and children. His children are ages 16 to 27. Mr. Rhodes does have his GED. He was not working prior to his arrest. He does suffer from seizures. He also had a work-related accident which injured his back, and that has also affected his ability to work. He has filed for disability checks, and he has been going through that process to try to get those started. Because of his financial situation and medical diagnosis, which affect his working ability, I would ask for, in case 22 CP 214197, where Mr. Rhodes is a no bond, we would ask for bond to not exceed $10,000. And for position 5, 22 CP 214060, where he has a $20,500 bond, we would ask for that to be reduced or cut in half to $10,000.
He's gonna
Total.
He's gonna live in Villa Rica?
Yes, Your Honor.
Okay. All right, what says the state?
Judge, given this, well,
Thanks, Skippy. It's once a week now. Fix my camera settings too. It was brutal.
Judge,
StreamYard's
the-
brutal.
the state sees no compelling reason to reduce the bond on position 5 from the 20.5 thousand that it is. The state would actually not object to a bond probably equal to that amount on position 4 where he's in currently no bond status. Nothing further.
All right, so we got 8,000, 10,000,
I wonder if she'd yell at me
1,000
if I took
on
my
position
socks
4.
off.
No drugs unless prescribed, no alcohol,
Put
no
your
weapon.
socks
For the
on.
contact with Kevin. ORELL. Stay away from 3107 Sylvan Road. Stay out of Fulton County unless you're here for court or to see your lawyer. You're gonna have an ankle monitor over that 24-hour curfew for court, lawyer, medical. Is he gonna have a job?
Your Honor, we're not sure about that at this point. His injured back is very limiting in his employment.
All right, so medical. But the only reason you come to Fulton County, sir, is to see your lawyer or go to court. Fill up with gas wherever you go. Make sure you got air in your tires. Leave a snack in the car because I don't want you to have to stop and get a snack while you're in Fulton County. That's not allowed. Position 5, no drugs unless prescribed, no alcohol, no weapons. Stay out of Fulton County unless you're here for court or to see your lawyer. Your ankle monitor is going to be paid for by the county with a 24-hour curfew. Court, lawyer, and medical. No further contact with your co-defendant, Patricia Sanders. No driving. Let's see, wait a minute. Stay away from 1286 Millage Street in East Point, Georgia, which is in Fulton County. Shouldn't have a problem with that because you're going to have to stay out of Fulton County. 2,000 count 1, 2,000 count 3. I mean, count 2. 2,000 count 3. 8,000 count 4. 200 count 5. 2,000, 2,000, 2,000, 8,000, and $200. You got that, Miss Hunter?
Yes.
All right. Best of luck to you. You can leave the booth. Bruce Wallace. Bruce Wallace. Wave your hand if you're Bruce Wallace. All right, no Bruce Wallace. What about Jeffrey Fain? Jeffrey Fain. No Jeffrey Fain. What about Rashadi Waring? All right.
Judge, his attorney has requested that the case be reset. He has a conflict where he's in Coweta County.
On Mr. Waring's case?
Correct, on Mr. Waring's case.
All right, sir, this is going to have to be reset. Your lawyer can't be here. He has a conflict. We'll get you back on there. When?
I'll just send him, I'll send the attorney a reset date.
We'll send him a reset date. You still have your $50,000 good bond. You can go ahead and leave the booth, sir. Brandon Miller. All right. Mr. Olaf, it's position 15, 22CP 212182. 194 days without indictment, no bond as of October the 5th. There is burglary in the second degree times 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 counts of burglary in the second degree. Possession of tools for the commission of a crime, possession of firearm by a convicted felon, and possession of a knife or a firearm during the commission of a felony. Pre-trial.
In regards to Mr. Miller,
That's a
11 prior
good one.
arrests in Texas and Louisiana. Open case 20 CP 190843. Burglary. Convictions. Burglary. 2018 conviction. Burglary. 2018 1 misdemeanor. And prior criminal damage to property, 3 counts. Nothing further.
All right. Go ahead, Mr. Olaf.
All right, thank you, Judge. Mr. Miller is 37 years old. He's from Dallas, Texas, but he's lived in Georgia for the last 8 years.
What up, Mayor?
He has his mother here and some friends. He's made it to the 12th grade. Before he was arrested, he was working at 24 hours as a cleaning company.
Hold on.
for,
2 North. Get in here. If you're not finished, get in here and sit down. Go ahead, Mr. Olaf. No,
Before he was arrested, he was working at 24-hour cleaning It's a cleaning company that services businesses and hotels. He can get a job back there if released. He's an active member of the Church of God, and he does a lot with them, including helping in their music department and evangelism and missionary department. Obviously, he's been in jail. He's been for quite some time, so he's indigent at the time. So we'd ask to request a bail for as low as possible. His address would be 411 10th Street, number 6. That's Atlanta, Georgia, 30309, which is in Fulton County. And to be staying there with a best friend. And I would also like to mention, Judge, that his co-defendant in this case has already received bond. Thank you, Judge.
What says the state?
I would definitely go on that court crawl without a doubt. Go live all the time.
Judge, I'm just looking at the co-defendant's bond. And
I'd be there. You kidding me?
I'm having trouble doing that.
I have the summers off, so let's roll.
4 South, booth 1. You got something interesting happening out there?
I'm in, Natalie.
4 South. There you go.
Is that me?
Judge, the state
I was talking. Sorry.
would
Sorry.
suggest that a bond that mirrors the co-defendant's bond may be appropriate in this case.
All right, sorry.
And I'm sorry, Judge, I'm having trouble doing the math on it right now.
That's all right. It's just now. Hold on. Getting it
Pick up
pulled real
McNally.
quick.
All right. Judge, with your permission, I'm going to step away from the platform for just about 15 seconds.
Sure. We'll go ahead with no drugs unless prescribed, no alcohol, no weapons. Stay away from 268 Westminster Drive Northwest. No further contact with Josh Carr, C-A-R-R, John Napoleon, Daniel Ramos. Pick your head up, 4 South, booth 1. Parnell Watson, Keith Carter, Brandon Sham, Otto Gunter, Ferris Lyon, Gloria Chang, C-H-A-N-G, Jacob Taylor, Carolina Blairy, B-L-E-R-I. No further contact with the co-defendant Terrence Logan. You got ankle monitor paid for by the county with a 24-hour curfew. You can only leave for court, lawyer, or medical. Stay away from all public storage facilities or any other storage facilities.
Public storage.
Looks like they're charged with almost
Thieves.
the same thing. So on all the burglaries in the second degree, be $5,000 on all the burglaries. $1,000 on the possession of tools for a crime, and then $10,000 on each possession of firearm by a convicted felon and possession of firearm during the commission of a felony. $5,000 on each burglary, $1,000 on possession of tools for a crime, possession of firearm by a convicted felon 10, possession of firearm during the commission of a felony 10. That ankle monitor will be paid for by the county. Best of luck to you, sir. You can leave the booth.
Thank you.
Let's see, did Jeffrey Fain come in? All right, Jeffrey Fain. Ms. Rondon is position 14, 22 CP 211952. 202 days without indictment. There is a $70,000 good bond on theft by receiving stolen property. Felony, theft by receiving stolen property, misdemeanor, unlawful for a person employed by, associated with a criminal street gang to conduct or participate in criminal street gang activity. Unlawful for a person to acquire, maintain through criminal gang activity, proceeds derived from that. Pre-trial.
7 in Georgia, 1 in South Carolina. South Carolina was driving with a license suspended, 1 arrest for probation violation, currently on probation for meth, 10-4-21 for 3 years, I believe, out of Franklin County. Nothing further.
All right. Go ahead, Ms. Rondon.
Mr. Fain is 29 years old. He is a lifelong resident of Hartwell, Georgia. Both his mother and his father's side of the family live
Fit
there.
right in, right, Whiskey?
He does have a good address. That is 801 Athens Street in Hartwell, Georgia, 30643. It is his father's address, where Jerry Fain, where he will be living. Mr. Fain has his GED. He has 4 kids, ages 2 through 12. Prior to being arrested, he was working for CLC Tree Service. He had been with the company for 5 years, and we are absolutely positive that he could get his job back once released from custody. Since Mr. Fain has been in custody for 202 days as of today, we are asking for a reduction in the bond amount. Since he has been out of work, he cannot afford the $70,000 that his bond is currently at. We would ask for a reduction for the total amount not to exceed $30,000.
I think did I skip you again?
No, you did not.
I didn't think so. Okay, I wrote it down. All right. What says this? This is going to be Mr. Hiles. Go ahead, Mr. Hiles.
Your Honor, Mr. Fain is a member of the Aryan Brotherhood, which is a white nationalist gang. He does not have any ties to the community, being from Hartwell. He also has holds out of state in Franklin County, South Carolina. We feel that based on his criminal history and the charges that they are, that $70,000 is a fair bond. And we would ask that it remain as is.
Well, it's definitely one that I set. No drugs unless prescribed, no alcohol, no weapons, no further contact with Rance Morgan, Morgan. No further contact with Kayla Hawkins. You can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical. Stay out of Fulton County, sir. The only reason you come to Fulton County is see your lawyer and go to court. No further contact with your co-defendant, Amber Brake. And no further contact with Christopher Lomanek, Lomaneck. And also no replicas of weapons. No further contact with anyone that's a member of the Aryan Brotherhood or white nationalists or any of those white supremacy people, any members, affiliates, gang members, relatives. If you think they're trying to become a member, you can't have any contact with them. So do away with all that stuff. Theft by receiving stolen property. 25,000. Theft by receiving stolen property, 10,000. 100,000 on each gang charge. Best of luck to you, sir. All right. Jaquez Green. All right. Mrs. Smith, there you go. 22 CP 212362. 186 days without
Definitely
indictment. No
would.
bond as of September the 16th. Terroristic threats and acts, willful obstruction, misdemeanor. Pre-trial.
Prior arrest, a couple of felonies, prior entering auto, nothing further.
All right. Go ahead, Ms. Smith.
Your Honor, first I want to note that my client, his legal name is James Long, but his alias is Jaquez Green. And the legal name James Long, it is on his pretrial in his booking report. Mr. Long, he is 56 years old. He is a lifelong resident of Atlanta. He does have community here. His family lives here. He has 4 daughters and 2 sons. One of his sons, his youngest son, actually, he is the primary caregiver for, and he has been the primary caregiver of his son since he was 5 years old. Mr. Long, he is a high school graduate, and he did complete 2 years of college. Before his arrest, he was not employed because of his disability. However, he was very involved in his son's school activities, so he volunteered often at his son's school. He does have a good address, which is in East Point. It's 2278 Connolly Place, East Point, Georgia, 30344. I did put in a change of address for him. This is the address of his daughter. So he'll be staying there upon his release with his daughter and 2 of his grandsons. Your Honor, as you've heard, Mr. Long, he has been in custody for 186 days without bond or an indictment. So he is entitled to bond. So we are requesting a bond not to exceed $2,000 in this case, $1,500 for count 1 and $500 for count 2. Also, Your Honor, if you do find it necessary for there to be a stay away from the incident location, we are requesting for there to be at least one-time allowance for Mr. Long to visit the incident location with police escort so that he could retrieve all of his belongings, since that incident location is where he shared the apartment with the alleged victim. And then we are also requesting, instead of there being a no further contact order from the alleged victim, we are requesting a no further violent contact order, just because they do share a son between the 2.
And where will he live?
It's in East Point. It is in Fulton County.
That is, okay. All right, what says the state?
Judge, it does appear that one of the primary victims, the 12-year-old Mr. Jalen Long, is currently in custody in the YEC. Or it looks like an act of violence against a police officer. Given that development, the state does not find the request by the defense counsel to be unreasonable. Nothing further.
All right, what was your numbers again, Ms. Smith?
Not to exceed 2,000, 1,500 for count 1 and 500 for count 2.
All right, so no drugs unless prescribed, no alcohol, no weapons. Stay away from 875 Hank Aaron Drive. You can return one time with law enforcement to pick up your belongings. That's one time only, sir. And Jalen, the minor child, I'll only allow contact with Jalen. I'll just let, there's gonna be a juvenile case open, so we'll let juvenile court determine that kind of contact, right? Because if there's something like that, if there's a case open, juvenile will control that. If it's not, then were they married, or is he legitimated the child?
I don't believe that they were married, Your Honor.
So I can't make her let him see them. I don't know how they're getting along, but we'll just say no further violent contact, only about the child. Because if this happened, there's cruelty, there should be a defects case open or a juvenile court case open, and we'll let juvenile determine how much, how often or whatever safety plan they get to work out. So I'm gonna do 2,500 on count 1 and 1,000 on count 2. Best of luck to you, sir. You can lay the booth. All right, let's see.
Your Honor, did you say 2,500 for count 1?
Yeah.
Okay, that does complete my business, Your Honor. May I be excused?
Yes, ma'am. Have a good one. I got
Thank you.
Solomon Adaradam. I'm sorry, I probably destroyed that, sir. You hear? Thank you, sir. I do apologize that I can't pronounce it. I'm sorry. It's position 7, Bostic. It's 22 CP 208908. 317 days without indictment. There's a $130,000 good bond as of September the 26th. Armed robbery, aggravated assault with intent to rob, theft by receiving stolen property, misdemeanor, and obstruction. Pre-trial.
Good one. There we go, Manning.
Oh, just talking. Prior arrest, 2 holes, FTA in McDonough, FTA in Decatur. Open case for battery out of the cab. Nothing further.
All right, go ahead, Mr. Law.
Mr. Abdurrahman, something I grabbed wrong notes. Yeah, Mr. Abdurrahman is age 18, he's about to turn 19. He was born here in Atlanta, Georgia, where he lives with his mother and his siblings. He didn't finish high school, though he has worked with his mother's clothing business, that she owns here in Atlanta. His mother is here on the call. Her name is Latifa Abdurrahman, here to support him. Upon his release, he would be able to live with her at 1131 Green Yard Way, Norcross, Georgia. And an important factor in reducing his bond is that Mr. Abdurrahman has a chronic condition called sickle cell anemia that's genetic, that requires critical care when there are medical crises involving this. He's had several of these crises while inside the jail, and he's had to go to the medical unit several times for that. And he really needs to get out of the jail with a reasonable bond so he can get more long-term chronic care for these issues. He also has MH issues that are best addressed outside the jail as well. And given that he has got those medical issues, and he's got good support of his mother, we are requesting that his bond be reduced to below $70,000.
Right, what says the state?
Judge, the state would note that we have been unable to establish victim contact with either the primary or the secondary victim in this case. No further argument at this time.
So they do live in Fulton County, Mr. Lyles?
It says Norcross, Georgia. I'm not sure if that's in Gwin.
Yeah, I don't
believe
think that's in Fulton. All right, let's see. No drugs unless prescribed, no alcohol, no weapons. No further contact your co-defendant, Armon, Armon Stevens, Stevens. Stay out of Fulton County unless you're here for court or to see your lawyer. I think I already said no drugs, no alcohol, no weapons. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical. Graduated high school yet, sir? Thumbs up or thumbs down? So you want to go back and get your GED? All right, so we'll let you leave for your GED, but you must show enrollment in your GED. One of your bond conditions also, sir, is you have to pay back your mom. Any money that she comes out of pocket to get you out of jail, you have to pay her back that, either in cash or in sweat equity. That means, I hope you're not smiling because I'm serious, because if you're not paying your mama back, we'll put you back in jail. So if she says, cut the grass, I will pay you $5 an hour, then that $5 an hour comes off of what you owe her. But this is not a her problem. This is a you problem. And it's not for her to pay for it. I don't know. I know previously there was a hold, but if that you'll have 48 hours to have that ankle monitor placed on your ankle if there is a hold. No further contact with SRI, last name Vanga, then Sanket, MAHESWARI, and no further contact with Lauren Wright. $30,000, $30,000, $3,000, and $10,000. 30, 33, and 10. Best of luck to you, sir. I'll also send that one since it's been 310 days. All right, DeMarcus Jenkins, I apologize. 22 CP 209-034, 312 days without indictment, no bond as of May the 13th. Possession of firearm by a convicted felon, loitering and prowling, obstruction of a law enforcement officer, and theft by receiving stolen property. Then it's 22 CP 212-584, DeMarcus Jenkins, 312 days without indictment, unlawful for an inmate to possess any controlled substance, gun, or dangerous weapon, criminal damage to property first degree, and willful obstruction. Pre-trial.
In regards to Mr. Jenkins, 14 prior arrests, prior FTA, robbery in 2014, 2018 felony possession of marijuana, simple battery, 2019 firearm by felon, open case 22 SC 185460, schedule 2 substance fleeing and eluding, reckless driving assigned to Judge Whitaker, open case. Is that on here? 22 CP 212584, street gang, criminal damage and obstruction. Nothing further.
All right, yeah, that one's not on here, but go ahead, Mr. Lyles. Cause that one's
Sorry, were you continuing?
yeah, go ahead.
Okay. Yes, Your Honor. Mr. Jenkins is age 26. He was born here in Atlanta and lived here his entire life. His mother, father, siblings, nieces, nephews, entire extended family lives in the area. He has one child. She's an 18-month-old girl who lives with the mother, and he is active in her life. He received his GED in 2018 and was working with in South Fulton with the UPS as a packaging and handling before his arrest. And he is an active member of the Atlanta United Mission Church. He would live at his mother's address in Decatur, Georgia, 985 West Clubhouse Circle, Apartment C, upon his release. It's already been almost a year since this case. Still has not been indicted.
So we're winding
and
down
he's
now.
I believe he has finished all of his previous cases.
Mark, becoming a nerd.
That were keeping him in jail, other than this one. His probation has been
play
reinstated
some
on his previous
clips.
cases.
I have
So
good
we are
clips.
requesting that bond be set reasonably so he can get out on bond and get his life in order.
Play some Manning as
All right,
I
what
get
says the
everything
state?
ready.
Judge, the state would know that Mr. Jenkins was born in 1997, and it appears that he has spent more months incarcerated than he has out of custody since he turned 18. He's currently facing charges in 22 SC 185460.
Okay, are we ready for some clips? I think we are ready for some clips. Let's do it to it right now. Let's start the show. All right, let's go to our first clip out of Mr. Morgan's courtroom, and this is wonderful. Let's get rolling. Here we go.
Or parole, subjecting you not only to penalties in this case, but also to any penalties possible under the violation. Do you understand all the rights I just told you?
Yes, sir, I do.
Okay. Have you read the advice of rights form?
Yes, sir, I have. I was
Do you
reading
have
it as
any
you were.
questions? What's that?
I was reading it as you were telling me it. Yes, sir.
Okay. Do you need any extra time to read that?
No, sir, I don't.
Do you have any questions regarding any of the rights contained in that form?
No, sir.
Have you signed the form?
Yes, I did, sir.
Does it have your complete, current, and accurate address?
Yes, sir, it does. 109 West Beecher. 109 West Beecher Street, Adrian, Michigan, 49221.
Thank you. And your phone number?
517-745-7201.
In file 222553, it is alleged that you failed to appear January 5th, 2023 for a pre-exam and pretrial. And then in file 222569, it is alleged you failed to appear on January 3rd, 2023. Sir, you could plead guilty, not guilty, or remain mute, and the court will enter a not guilty plea for you. How would you wish to plead?
Your Honor, I was in the hospital at that time of U of M with my hand. I had 3rd-degree frostbite burns on my hand, but I was guilty because I didn't show up. But I did have reason.
Hold on. If you didn't show up because you were in the hospital, that's actually a viable reason for not showing up to the court. Do you
Yes,
have
sir.
documentation of that?
Yes, sir. My wife has it all. Matter of fact, the nurse upstairs has it. I released all the paperwork to her. As you can see, I just lost the tip of my finger on my first finger last night here at the jail. It was dead.
Okay. So, but you're saying January 3rd and 5th, you were in the hospital?
I was under hospital care, unable to get out. They had me so doped up, Your Honor, I couldn't move. I was going back and forth from Ann Arbor to Jackson to my aunt's, making sure I was making my hospital appointments.
All right.
Over 2/3 of my hand was frostbite. It was 3rd-degree burn.
Hold on. Which charge? Sir, also in file 222569, it is alleged that on December 5th, 2022, in the city of Adrian, county of Lenawee, state of Michigan, you were driving an automobile upon US 223 at or near South Main Street while your license was suspended, revoked, or denied. As to that charge, you could plead guilty, not guilty, or remain mute, and the court will enter a not guilty plea for you.
Guilty, Your Honor.
You know, understand, if you plead guilty, you won't have an opportunity to speak with a prosecutor, or they may, and I'm not saying they will, but they may offer a plea bargain. Knowing that, would you still want to plead guilty, or would you want to enter a not guilty?
I was wrong. I want to enter guilty, Your Honor.
Okay, I also just want you to know that the prosecutor's office have started new programs for deferring driving while license suspended. Knowing this, do you still wish to enter a guilty plea?
What does that mean, Your Honor? I defer.
Prosecution, well, basically the prosecutor office have new programs that deals with driving while license suspended. They may offer you a plea bargain or some form of sentencing agreement, or agreement that you wouldn't.
I would like to go to a program, Your Honor, so I can get my license straightened out, but I don't know what to do.
So at this time, do you want to enter a plea of not guilty, or remain mute so the court enters not guilty, so that you will stand?
I'll
mute?
remain mute.
Thank you. The court will enter a not guilty plea for you. You should have been, do you have a court-appointed attorney for the felony?
No, sir, I don't. No, sir, I do not.
So you have to sign.
Well, what about the OWI? The 222553.
The PD, you were supposed to go. I don't know whether or not.
I'm also going to order you be evaluated and assigned a public defender in file 222569. If you've not already received one, I'll also order you be evaluated and received, if you're eligible, in file 222553. Sir, based on your claim that you were in the hospital, and also that we can obviously see your hand is bandaged, I am going to grant you a PR bond in both these cases, but you do need to appear.
I will. Your Honor, I tried to keep track. I tried to call I had my wife call the county clerk to let them know what was going on.
Okay, hold on.
And
hold on. I'm assigning you a public defender, so I don't want you to say anything that may compromise your cases, okay?
Yes, sir, I understand. Thank you.
March 27th.
Your next court date will be March 27th at 9 a.m.
Yes, sir.
You need
I
to
will
get with
be
the
there.
public defender. You need to get with the public defender's office to be evaluated and have, if you're eligible, having a public defender assigned. You need to be here.
Also has a real.
And so March 27th, 2023 at 9 a.m. That will be probable cause conference and pretrial. And then April, you said 10. And April 10th at 9 a.m. you are scheduled for an exam at that day and time. All right?
Yes, sir.
You should
Will I
receive
get a
notice.
copy of this?
You should receive
I'll get a
notice at
copy
the
of
jail.
it.
You should receive
Thank you, Your
notice
Honor.
at jail. If you
Guy's
don't
out of his
understand, you
mind.
still need to be here on those days and times.
Yes. Yes, sir, I will be.
So Marina,
Sir, I'm going to reiterate, though, you do have bond conditions in file 222553. What that means
Yes.
is no drinking of alcohol of any kind.
Yep.
You are to submit to twice daily PVTs. This was signed.
Your Honor, may I stop you right
December
there? Up until I had my accident with my hand, I was up at the PVT machine twice a day, every day. I made sure I made that.
Hold on. Then as soon as you're released from jail, you are to report to the probation department, all right?
Yes, sir. Right across the street, correct?
In the courthouse here.
Gotcha. Thank you.
big handle wrapped
And that
up.
is all in this matter.
All right. Thank you, Your Honor.
Make sure you bring notification or documentation of your hospital stay, all right?
Yes, I will make sure, if not today, tomorrow, I'll have my wife dig it out and I'll drop it off at the probation department.
Bring it to you may want to talk to your attorney about it, all right?
Yes, sir. Thank you, Your Honor.
Then that is all in this matter.
Thank you.
I have nothing.
All right, so I have, believe it or not, okay, believe what you want, but I have in the Discord, and got My Crazy Life, Sean, Michelle, Laura, Monica, everybody going crazy, and we're just going clips all day. And then if I go away for 5 minutes, it's just clip. And it's a great thing. I love it. So this one, I'm just giving everybody credit because we all just share together. So the next bunch of clips are basically from my mods. So I'm giving all them the credit in the world because they are on it for me all day. Even when I'm at my other job, even when I can't, they pick right up and they do it the right way. They put record. They don't just do it so we lose the live feed. So we are rocking and rolling. So Manning is winding down. So the room's probably going to pick up. We always have a constant flow. I enjoy you guys being with me. So let's rock and roll. This guy has to learn some courtroom etiquette. Best part, judge doesn't even care. Judge could care less.
Further to add, Your Honor.
Yes, I can. I just missed the name of the defendant.
Okay. So yeah, status
No
is
objection
May
from
8th,
the people.
and we haven't set a trial date.
Mr. Counsel or Mr. Counsel by way of Mr. Andrews,
And if that's
I'd like to
something
hear
we
why
do
you
the
want this to
trial,
happen
maybe that
today.
90-day clock will start.
Your Honor, my client.
Okay. That takes us to.
There's Mr. Mariner on Zoom. Joseph the Mariner is up there, isn't he? I see him.
You're on. This is next case on the docket. Joseph Mariner. Mr. Mariner, if you could unmute.
Yeah, I'm here.
Okay. Your Honor, this is a pending DUI that we're getting close to resolution. My client had an eval, but what I don't have. Mr. Mariner, are you still in Forks or are you, because the place you got the eval from?
Is in Olympia.
Correct. So are you in Olympia or?
Yeah, I'm in Olympia for the time being.
Okay. Because I have the evaluation from Northwest Resources. What I don't have is a current compliance report. So I'm assuming you call them today, tell them I
Yep.
need a current
Oh, I
compliance
forgot
report.
Kitchen court cases.
And
Go
then
subscribe to her
we'll,
channel, guys.
on the 17th.
Here we go.
If you can be physically here, that would be ideal because typically change of pleas. I mean, we can do it over Zoom, but it requires a bit more logistics. Could you
Right.
be physically here on the April 17th?
Yeah, I'll try my best. Yeah, I should be able to be there for sure. But
Why don't we, let's work with the 17th, try to get you up, because you'd have to make some, whatever schedule changes you need to make, Mariner, get up here for your plea on the 17th, and if you're not here, we gotta set trial dates and or issue a warrant or whatever, so if you can't get up here on the 17th, let your attorney know. We'll be here April 17th at 9:30. We're gonna call it a disposition date.
Correct. And Mr. Mariner, that's almost a month out, so that should give you plenty of time to get me a compliance report. That way I can chat with the prosecutor. And then you can be physically here on the 17th so we can resolve your case.
okay, yep, that sounds good.
Okay, good. We'll see you then.
Yep, you guys have a good day.
Oh, thank God.
Thank you.
Come on. That's a first. I've never seen anyone with Q-tips. First time we saw Q-tips.
Lottie, yep, she's there.
All right.
Your
Now
Honor,
this
this
one,
is Edna
I
Pilati,
have
case
so
number
many good clips today.
6692000.
Oh my God. It was what a day. Okay, so this is Judge Grandma at her absolute very best for everyone. OMG, she was on it. So, Mr. Lyle over here, Mr. Lyle, okay, is a youngin'. Grandma is going to give him a speaking to. She took the plastic off the couch, she put the doilies in the cupboard, and she sat Mr. Lyle down, gave him some Ovaltine, and he's getting a stern talking to. Here we go.
Okay, go ahead.
I have had a chance to review it, Judge. It's accurate. No additions, deletions, or corrections. We'd ask the court to consider HIDA for this young man.
Yeah, Mr. Lyle, did I tell you to go over to flip the script when I saw you last?
No.
You sent it to
No.
the officer.
What?
No, ma'am.
Tell him she sent it.
Your mother's giving you some advice. I know I told you to listen to your mother when I saw you last. What is your mother telling you to tell me?
You sent it to the probation office.
Thank you. Did you get a job, young Mr. Lyle, since I've seen you last?
No, ma'am.
Did you enroll in a GED program?
No.
No. What?
Ma'am.
Counsel, your client's failure to be here on time, properly attired, knowing how to address the court is an indication to this court that perhaps he's in need of some type of services before I impose sentence. Before I impose sentence, because I'm not the least bit impressed this morning. And perhaps it should be explained to him as well. I'm not obligated to accept any agreement that's entered into between the parties.
Oh, you're not, Judge.
He needs to understand that as well. Young man, get pencil and paper.
He ran for that pen. His mom's right there yelling at him too. So he's getting mom and grandma. What up, Mikey? Credence and Bishop in the house. The legend, baby. While Mr. Lyle gets a pen. Mikey, you got snagged by the live button today. Oh, you're a pro, though. You had plan B, my friend.
Do you have pencil and paper available, young man?
Yes, ma'am.
You are to call the Flip the Script program. Flip the Script is the name of the program. It's a program that's run by old urban men for the benefit of young urban men, trying to keep the young urban men out the pen. Let me break it down for you another way. They've been there, done that, trying to keep you from being there, doing that, so that you don't have to end up in the penitentiary. Understand what I'm saying?
Yes, ma'am.
The phone number, 313-557-4848. The address, 2777 East Grand Boulevard, Detroit. If you can get to the corner of Woodward and the Boulevard, you can walk to the building from there. On the front of the building in real big letters, it says Goodwill Industries. You call them today, and the first thing you say is, Judge Deborah Thomas sent me. My name is. You only have to get there one time. They'll give you bus tickets to get back. But the bus, every bus line in the city of Detroit costs either. I beg your pardon. Are you talking while I'm talking?
No, ma'am.
Every bus line in the city of Detroit crosses Woodward or the Boulevard. And if you don't have bus money for the first day you need to get there, start walking the night before. Let me explain something to you clearly. You're not in school, you're not working, but you can't get up in the morning to come to court to find out whether or not you're going to spend time in the penitentiary, on probation, or what. I am not impressed. You call Flip the Script today. You keep calling till you talk to somebody. Remember, when you get in touch, the first thing you say is, Judge Deborah Thomas sent me. My name is. I got them on speed dial. I just hit one number. When you do come back for sentencing, you can actually call or zoom in from Flip the Script. Understood?
Yes, ma'am.
Don't go and see what happens.
Come on.
Have I made myself clear?
Yes, ma'am.
Emma, give me a return date about 45 days out. Plenty of time for him to be in the program for over a month.
Yes, ma'am.
Her court clerk is the best. Yes, ma'am. She's so scared to not answer.
I was May 1st at 9 o'clock in the morning. But since you will have been going to flip the script for over a month, you should be real comfortable with being up and dressed at 9 o'clock in the morning. They're going to teach you some life skills. They're going to help you get your GED. They're going to teach you how to get a job, and they're going to teach you how to keep one. Young man, get off of Zoom while I'm still in a pleasant mood.
Bravo. Bravo.
Our next case is Alexis O'Rear.
Ready, runner.
You should be in possession of the pre-sentence report, Your Honor. Yeah, I got that one. Hold on, let me pull it up.
All right, next one we're gonna go to. Just the lighting a little bit. Next one we're gonna go to. All right, so everyone knows my affinity for Judge DeSanto. She had some nutsos today. It was one after another. But I have a complaint. I need to email her or write her a letter. Whenever she moves, her chair sounds like she ripped one. It's not just a normal chair sound. It's very embarrassing. And as her court husband or boyfriend, I should let her know. I'm going to pull her over to the side and say, Judge, you move the chair around. It sounds like you're letting one rip. They're killing you in the comments for it. We hear it. It happens 2 or 3 times every 15, 20 minutes. Listen for it. I protect her. She's my girl. What could I say? Here we go. Let's roll.
And you understand the possible penalty as a result of your plea today, correct?
Yes, I do.
And knowing all that, you still want to continue with your plea?
Yes.
Has anybody promised anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, counsel, if you can please pardon your client.
Sure. Mr. Venable, is it true that you're currently on probation out of the Wyandotte District Court?
Yes.
As a term and condition of probation, you understand you're not to test positive for any drugs or alcohol that you don't have a prescription for?
Yes, sir.
Is it true that a drug test taken on February 14th
Have a good night,
of this
Mikey.
year, you tested
Bright and early
positive
tomorrow, baby.
for marijuana?
Yes.
And you understand that that's a direct violation of your terms and conditions of your probation?
Yes, sir.
Satisfied, Judge.
Everybody go check out Credence and Bishop. I don't have to tell you.
Plea of knowing, voluntary, and factually accurate. And the court will accept your plea. This is technical violation number 3. And sir, what don't you get? It's now your 3rd violation. You're not allowed to use marijuana, sir. Is it prescribed to you?
Judge,
no, it is not.
I'm going to get into that when I had a moment to speak. Mr. Venable has taken responsibility for the marijuana being in his system. However, if you look at, it was 39 nanograms per milliliter, which to me indicates a very small amount. His roommates and his father, who he lives with, they all smoke marijuana. So he indicated to me that he was not using, he's just around it. Moving forward, I told him he either needs to leave where they're using it or ask them to use it in their own bedroom or outside. Moving forward, I truly don't believe this is going to be an issue. I think that Mr. Venable had a rough start with probation, but he's been on probation now for roughly a year, and he has not had any violation in a significant amount of time, which indicates to me that he's taken probation very, very serious. I know he's adamant about completing and finishing probation. He pretty much all he has left to do is stay out of trouble and pay off a small balance that I know he's been chipping away at. So moving forward, Judge, this is not going to be an issue.
Okay, so Mr. Venable, you are telling this court that your positive test was from the people that you live with, they're smoking marijuana.
What's going on? Pay attention to the inmate, because this guy talking, yeah, whatever, it's the weed, but the reason why I recorded this clip was because of the inmate. So he's having a lot of interactions, there's arguing going on, and then we go right to him. So just hang out, listen to her talk to Venable, and then we're going to the inmate right after that. But you have to, the silent part is the best too.
Yes, I believe it came from them because I've been just trying to get off because I was ready for early discharge on March 20th, and I knew that, and so I was trying to be safe. You know, I don't even do anything. So being around them, I thought that secondhand smoke from marijuana was a myth. So I didn't think that it would affect me in that way, but I guess it did, and I made a dumb decision of being around them while they were doing it.
Yeah, okay.
I know it sounds, I know how it sounds, but I'm telling you the truth.
Okay, I hear what you're saying, sir, but I'll just say that I was just at a conference, just last month. And, one of the topics was this specifically. And so it really doesn't happen,
Yeah.
but in any event, if you were to test today, sir, what would be detected in your system?
Absolutely nothing. I actually have to test today.
Okay, well, the court's going to adopt the recommendation. You're going to continue to complete all terms of probation. You are going to pay a $50 probation violation fee, and we are going to increase your testing.
Okay, so do I get a new color from Alex or?
Yes, yes, sir, you're going to contact Alex and you will get a new color.
And so do I still test today for black or no?
I'm going to indicate that you're going to test today as well, yes.
Okay.
Thank you, Jeff.
Thank you. All right, we're going to have a good day. All right, off the record.
Have a good one.
Okay. So you as well.
Here we
Okay,
go.
so Mr. Westmoreland, we have the jail ready to go, and then Mr. Furman, we have to re-sentence because the ordinance is not for paraphernalia. So we have to re-sentence him under 771. So we just need to put that on the record. So
Okay. You want to do that real quick, and then I'll talk with the jail?
well, I want to do the jail first, just because they're back there with the jail. Wyandotte Jail?
I got it.
Terry, did you leave the file for me or no?
Send it, I'll get it. I'm just waiting for that.
So, you have any monthly bill? You definitely.
Okay, yeah, Terry, can you please hand me bring me the file, or hand me the file, please? Okay, so, all right, so then, okay, let me mute the jail there, and then I can't put you in a breakout room with the jail until I have unmuted Mr. Westmoreland. So do you want to have a quick conversation with Mr. Furman in a breakout room?
Sure, that's fine.
All right, Mr. Furman, sorry, I couldn't reach that.
Are you muted?
No, I'm not muted, hang on. All right, I'm going to put Mr. Westmoreland and Mr. Furman back in breakout room 2. Mr. Furman, jump to breakout room 2, please.
Yep.
Okay.
Where'd she go off the record? Yeah, she went off the record. All right, here we go.
So, Mr. Westmoreland, that will be breakout room.
They'll be able to tell you more. So this is.
Serenity Noble.
All right, here we go.
You're about to give this man the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, thank you. All right, and you may proceed on the complaint and warrant.
Friday, March 17, 2023, approximately 17:27 hours. Wyandotte officers were notified that Trenton PD was chasing a vehicle that was taken in an armed carjacking earlier today in the city of Dearborn. Trent was chasing the vehicle northbound on Biddle, entering the city of Wyandotte, Pennsylvania. The vehicle was a silver 2011 Dodge Escape. Ford Escape. Wyandotte officers in fully marked police cars in uniform were positioned at Biddle, Pennsylvania, and they joined the pursuit northbound on Biddle. The vehicle was traveling well over the posted 35-mile-an-hour speed limit, reaching 80 miles an hour. The vehicle entered downtown Wyandotte at speeds that's over 70 miles an hour in 25-mile-an-hour zone, disregarding all traffic control devices, passing other vehicles in the center lane with a large crowd of people in the downtown area for the St. Patrick's Day holiday. Trenton police terminated. Officers took the lead in the pursuit. The vehicle continued to travel at speeds over 20 miles an hour northbound on Biddle into the city of Ecorse. The vehicle turned westbound on Southfield at speeds between 50 and 70, disregarding all traffic control devices. Entered northbound 75 from Southfield and continued to travel at a high rate of speed. Once in the city of Detroit, near the Clark exit, Wyandotte officers ended the chase by forcing the suspect vehicle into the center median, the cement barrier. The driver, later identified as the defendant, David, exited the driver's door, jumped over the center median, ran across to all traffic lanes of southbound I-75, with officers chasing, giving loud verbal commands to stop and get on the ground. The defendant continued to run from officers and entered a construction area near the Gordie Howe Bridge. The defendant entered a water retention area and laid it on his back, and the officers were able to take him into custody. A search of the defendant, officers located 48 9mm bullets and 122 caliber bullet in his inner pocket. The defendant refused to identify himself to officers and give his name. They had to use a mobile fingerprint scanner to identify Mr. Davis. Davis' driver's license currently suspended, and he has 2 previous felony conspiracy to commit armed robbery in Wayne County in November of 2012. Mr. Davis has a parole absconder warrant, and they placed a detainer on him. And Dearborn police are seeking a carjacking warrant against Mr. Davis.
All right, thank you. As a nuisance complaining witness, I find the offenses charged were committed. There's probable cause to believe that the defendant committed those offenses. And counsel, your appearance, please.
Good morning, Judge. Attorney Corey Westmoreland appearing on behalf of Mr. Davis.
Oh, that would have been great.
All right, thank you, Mr. Davis.
Yes, ma'am. Stand up.
Your name, please.
Mr. Davis.
I'm sorry?
Mr. Davis.
Okay, is your first name Mr. or is your first name Kenneth?
Yes, Kenneth.
Okay, so please state your name for the record.
Kenneth Davis.
All right. And counsel, as to the arraignment?
Yes, Your Honor. At this time, I did have an opportunity to speak to Mr. Davis at length regarding the charges. We are prepared to waive a formal reading. My client stands mute.
All right. The court's going to waive the formal reading. Sir, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you had an opportunity to speak to an attorney today, correct?
Right.
Is that yes?
Yes.
Okay. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. And you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes.
All right. The court's going to enter a plea of not guilty on your behalf. Schedule this matter for a probable cause conference on March 30th at 9 o'clock in the morning. And counsel adds to bond, and then I'll give Detective Sergeant Grow an opportunity to respond.
Yes, Your Honor. I would like you to know that Mr. Davis is 30 years old. He does have one child. He is not married. He currently resides in Romulus. He currently is on parole. I don't believe he has any other pending matters outstanding. And after speaking with him at length this morning, Your Honor, he did assure me that he would be appearing at all future court dates. So I don't believe he would be a flight risk of any kind. I would just ask that that all be taken into account when assessing a bond on behalf of Mr. Davis.
Okay, thank you. And Detective Sergeant Grote, Esteban.
Your Honor, Mr. Davis thinks this whole thing's a joke. He doesn't want to cooperate. As you can see, he didn't really want to tell you his name. He doesn't want to cooperate with us. He told me he's homeless. He sort of bounced from place to place. He's a violent gentleman with a violent past, and I believe he thinks the judicial system's a joke. We're going to ask for $1 million cash.
You a mug.
Mr.
Hey.
Mr. Davis?
Yes,
Mr.
ma'am.
Davis? Please
Yes,
stand
ma'am.
up. Where is it you reside? I'm sorry?
I'm sorry, what'd you say?
Where is it you reside?
For this matter, I can reside at my mother's house, but on a normal basis, if this wasn't to happen, I would probably be just sleeping in a hotel room. Everybody
So let's
scratching.
try this again. Let's try this again, sir. In everyday life, where is it you reside?
On a few days, I would stay. Man, I don't know what you want to tell me, but take me back to the hospital. Sit down. Sit
down,
fool. Like he's sitting there telling you all type of bull stuff about me, like I'm just a criminal person. Well, this time I ain't got time for this. Just take me back to the cell and have the next come get me. Like I'm sorry, Judge, for wasting your time. I apologize. Like I'm really trying to cooperate and be cool, but I can't, man. I got too much on my life.
Stop. You're not wasting my time. I'm just trying to figure out where you reside. So it's a pretty simple question, sir. Do you reside anywhere or do you not?
Like I have nowhere to live. I have parents. If you allow me bond with a tether, they will allow me to stay there. But on a regular day basis, I walk the streets. I have nowhere to sleep. I sleep on abandoned buildings. I sleep outside. Like, what do you want from me? I got a daughter I can't even see. Like, what else you want from me?
Sir, why don't you work?
Every time I get a job, man, they fired me. Like, I get a job through temp service, and all the other employees, they do whatever they can to get me to quit. And I quit, and I leave. Like, I can't take the peer pressure. I can't take this nonsense of people talking to me like how they talk to me.
Okay. So where's the last time you worked, sir?
I just recently, 2 weeks ago, I cleaned out some hotel rooms for the housekeeping. That was the recent job I just did about a week and a half ago.
Okay,
but the money I
where's
have in my possession, I get that from income taxes and work in other places. Like, I don't know. Like, what you want? Like, I don't know.
Okay, well, sir, what hotel was that you were working at?
Rodeo Inn? I think it was the Rodeo Inn.
Rodeo Inn?
Yes, ma'am.
Okay, and where's that located?
It's not the Rodeo. It's RWI. That might be Rodeo. It might be Rodeo. The initials is RWI. I don't know. It's in Romulus though. It's in Romulus, Michigan, by the airport.
Okay.
And that wasn't an official job. Like, I just met the lady, I just met the cleaning person lady, and she had me clean the room out, and she paid me herself out of her check. So that wasn't no official job or nothing. She was just being nice.
All right. And so, sir, what are you on parole for?
For armed robbery back in 2012.
Okay. And so, what time did you serve in prison?
I did almost 6 years in prison. I did 5 and like 8, 9 months.
Okay. So you were released, what, 2018, 2019?
2008. 2018. February 13th, 2018.
All right. And then how long are you set to be on parole?
I should have been off parole.
Okay. So why are you not off parole?
Once the COVID started, they started making me do videos, Zooms, and I lost my phone. I never got back in contact with the lady.
Okay, was one of the conditions of your parole to have stable housing or employment?
They told me just as long as I have a phone with Zoom and I can contact them, they can contact me, I was okay. Then they had put me on a tether, and once the tether was gone, they just told me they'll contact me whenever they contact me.
Okay. All right. The court's going to indicate after hearing from counsel, hearing from Detective Sergeant Grote, hearing from Mr. Davis, the fact that Mr. Davis is on parole for a violent felony as a parole absconder. Given the nature of the charges, the safety of the public at significant risk, the court's going to, and the fact that Mr. Davis does not have any stable housing, the court's going to indicate a $1 million cash bond.
Million.
I will not leave my game, and that's fine.
In the event bond is posted, GPS tether, house arrest. Not to possess or consume any alcohol or drugs unless prescribed. Anything else?
Not this time, Judge.
All right, thank you. Have a good day.
Yeah.
All right, and we are going to recall the matter of
All right, so I got an even better
Daniel Furman,
Judge Mom.
2332.
Even a better
appearance
Judge Mom.
counsel.
So here we go right here. And what happened was, for some reason, I lost. Thank you, Heather. For some reason, so we're going to check it right here. For some reason, we're looking at Berto Hernandez. And now you can just listen in. Listen to this guy.
The allegations
oh my
are
God.
a bit concerning that you're in the middle of a road, a busy road, and that you were throwing objects at cars.
I was walking home from the hospital.
You were walking home from the hospital?
Yeah.
Is that yes?
Yeah. Correct.
You didn't have anybody that could pick you up?
No, not at the time.
And so what have you been at the hospital for, sir?
My girlfriend had assaulted me. I took the EMS. The reason why I couldn't get a ride home is I took a EMS to the hospital.
And so when were you at the hospital, sir?
A couple hours before they arrested me. I was walking from the hospital.
So you were in a state that was significant enough that you needed to be transported by EMS. And a couple hours later, you were able to just leave the hospital without any issue?
I was there for a while. And when they discharged me, I couldn't find a ride, so I started walking home.
Okay. And it appeared as though you were intoxicated at the time of this offense, correct?
Correct.
And that you were in such an intoxicated state that you thought it was a good idea to throw objects such as rocks at cars.
I wasn't throwing rocks.
What's that?
I wasn't throwing rocks at them. I was walking.
In the middle of the road?
No, because the way you had to cross from the hospital, I had to across through the middle to get to the other side.
All right. Sir, given your criminal history, it would suggest that you do not have a good relationship with alcohol.
Correct. I haven't been drinking.
Okay, and what about marijuana? When's the last time you used marijuana?
Around that time.
And so if you were to test today, sir, what would be detected in your system?
Because I smoked a lot of marijuana, it should still be in my system, but that's it.
All right. After reviewing the report, the recommendation, hearing from counsel, hearing from Mr. Hernandez Alviso, the court does find there's reasonable grounds to depart from MCL 769.5. The court does find the recommendations appropriate. Sir, the court's going to indicate 12 months probation. You are eligible for early discharge. I'll go over that in just a few moments. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, whether in person, in writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. And so, sir, you're going to be tested today. So your levels should be pretty low for any marijuana, correct?
Mm-hmm.
Is that yes?
Yes, correct.
Okay. The rehabilitative goal excuse me, for that condition is to monitor, so the court can monitor your progress in maintaining absence and sobriety. You'll have to participate in the chemical awareness program. The rehabilitative goal for that condition is to further educate you about drug and alcohol use.
Okay, here we go. So now what we're going to do is, this is from my boy Sean. He dropped it in my old Google Drive. And Sean, check your Discord when you get a second. Apparently I copy content now. That's a big thing. I copy content. Been doing my own thing for a month and a half now, and apparently I copy content off of something that I posted a couple hours ago, but I do the same content. So I'm not even going to show the clip that I had. Don't care. I enjoy the 100 people I have with you, because it's the best 100 people on YouTube right now, because you're with me and you're enjoying content. Just going to keep my mouth shut and not be petty about anything. All right, here we go. Mike Page is the man. Let's roll.
All right. Can you both hear me?
Yes, sir.
Yeah. All right. We'll take up file 2019-56802. Tiffany Weck and Jeremy Shelton. Both are here, it looks like, via Zoom. And this is the date and time set for a hearing in this matter. Your identifiers just say iPhone. Sir, you're Mr. Shelton?
Yes, I.
The man, you're Ms. Weck?
Yes, I am.
All right. So we'll proceed then. This is the entire separate hearing by friend of the court. There's a separate show cause based on the complaint that was filed alleging denial of parenting time. Both raise your right hands. You both swear or affirm any testimony given this cause to be the truth, whole truth, and nothing but the truth, so help you God?
I do.
I do.
All right. Sir, what led you to file the complaint with the friend of the court?
Mrs. Weck refused to let me take my kids on a Saturday or on a Friday. And then proceeded to not let me have my kids, with telling me that CPS was informed her not to let her take the kids. And then after a few days of nothing coming about of the CPS charges, Mrs. Weck still denied me of parenting time again on Wednesday, and I then tried to get a hold of CPS, tried to figure out what's going on because I wanted to get this solved before my next parenting time. During that time, I didn't get anywhere, didn't hear nothing from anybody. Mrs. Weck then proceeded to tell me she wasn't going to let me take them again on a Wednesday. I then told her that I hadn't heard anything from CPS, and from what I understood, CPS needed to contact me within 72 hours of any incident being charged with anything, and that I'm going to come down with law enforcement and get my kids if I needed be. At that point, she did let me pick up my daughter that morning, and I have had parenting time since.
All right. So you alleged that on February 17th, that was a Friday, you were denied parenting time?
Yes, sir.
What time were you supposed to start parenting time on that day?
Well, the kids didn't have school that day, so I was hoping that I could grab them that morning. It was President's Weekend, so they had Friday and Monday off. So I was hoping to have them in the morning, and Mrs. Weck said no.
Your order says from before school until 6 p.m. on alternating Fridays?
Yes, sir.
Is that one of the alternating Fridays?
Yes, sir.
All right. And then Wednesday from after school until 7, was that the 22nd?
Yes, sir.
All right. So, ma'am, do you agree that you denied parenting time on the 17th in violation of the order that says he's supposed to have parenting time from before school until 6 p.m.?
Can you say that again? That was his weekend, and per the standard parenting time, if it's a holiday, if it's a Friday in question, he would get them at 3 p.m. as if they were in school until that Sunday at 7 p.m. And yes, I did deny.
This says father shall have parenting time from before school until 6 p.m. on alternating Fridays. So you don't feel that you violated the parenting time order because of holiday parenting time?
No, that's confusing because from before school on Friday, they're typically in school on Fridays.
Yeah.
And that day happened to be a holiday. So I told him originally that he could pick them up at 3 p.m. and that was his weekend. So he would have them traditionally until 7 p.m. on Sunday, not just until 6 p.m. on Friday.
All right. Where'd you come up with 3 p.m. on Friday?
The standard parenting time, it said that for Fridays in question is a holiday, the pickup time would be 3 p.m. I have the order. I got that information from the standard parenting time.
All right, but February 17th wasn't one of the holidays recognized in the policy, though.
Yeah, that was a school holiday or a school day, typically.
So that wouldn't apply to that then.
Okay.
The policy the only holidays that are specifically outlined in the policy are subject to that provision.
Okay. But yes, I did deny parenting time on that day. I was alerted at 11 a.m. By the individual who submitted the CPS case that it had been turned in and that it was being investigated. While I was on the phone with her CPS, the CPS caseworker did show up at my house. She interviewed me. She went through my entire house. The children were home. She did not interview them at that time. I had all of them, including an extra child at that point. Upon conversation after she interviewed me, I did show her videos in question. I don't even know what was put in the CPS case. She asked when the children went to their dads again. I did tell her 3 p.m. She said that it's typically a recommendation. I was alerted that it was typically a recommendation that until the child has a CAC interview that they don't go, that she could not tell me to break the court order, but that is the typical advisement of the CPS department is to keep them. I said, I did tell her, like, if that was going to be something that was advised, if she could reach out to front of the court so at least they know. I provided her Heather, Jordan's contact information, Rachel's, and then Rebecca's. And she was able to make contact with Rachel and let her know that there was an open CPS investigation. So that is the recommendation that I took. Then that following Wednesday, and I'm not sure the date of it at that point, or without looking at my calendar, I've continued following that recommendation because my child was not interviewed with CAC until the next Friday, so 7 days later. Nothing was disclosed, and because there was nothing disclosed at that point, then I did receive confirmation from the CPS that they were not able to, the recommendation was no longer valid, that they didn't recommend keeping the kids. And at that point, then I resumed Mr. Shelton's parenting time as noted.
All right. Did they ever mention motion for an ex parte order?
They said that was an option, but because by the time on a Friday to get an ex parte written and then in front of a judge, it was so late.
That's really your only remedy would be to attempt to have a change to avoid a finding of contempt.
Correct.
The CPS worker was right. They can't tell you to violate an order. They can make a recommendation, but they should also say, ex parte relief may be available if you file a motion to have that considered. Because then at least the court can look at it and say, yeah, maybe parenting time should be put on hold while this is pending, or maybe not.
Come back, Mayor.
But you didn't take that step. What were the allegations that led to CPS being involved?
I have not seen the report, and I have not been alerted to the full extent. My understanding is that it was sexual related. Mr. Shelton has sent me videos of the children naked, either videos or pictures of them naked. Our oldest is almost 9, so she's developing. And then our oldest has actually videotaped herself on a cell phone that Mr. Shelton has provided her that are very provocative and concerning videos. And then I'm assuming that's what it was turned in by. I'm not sure what was disclosed by my daughter to the person who turned it in. I did not turn in the CPS case.
Bravo, Sean.
I did not file it.
But they did do the interview at your house with Abby there, correct?
Abby did not turn this in. CAC did not, or CPS did not have any conversations with Abby at that time.
Okay, that's what Demi told me. That's the reason I asked. She said that Abby was at the house and they interviewed her and you and everybody else. So
no, they did not have any interviews with anyone other than myself, but they did go through my entire house at that time. And Abby was there, but Abby did not turn in the CPS case, and I did not turn in the CPS case. So I still, to this day, don't know what was fully turned in or what the allegations were.
I ordered it. I actually have the lady sending it to me. I had asked to go through process, so they just came to my house the other day, and I found out what they were trying, or whoever filed what they were trying was pictures that I sent with a video of my daughters jumping on a trampoline in the summertime with the sprinklers on. They had soap, took Dawn dish soap and put it all over the bottom of the trampoline and was jumping all over, slipping and sliding and having fun. I did take the video and send it to Mrs. Weck, and I said, look, I can't keep clothes on him here either. Because prior to the day of this, my Tiffany FaceTimed me and Mrs. Weck FaceTimed me while my kids were jumping in and out of a water trough naked. And so, we were getting along at the time. We were actually being kind of cordial to one another. I was trying to involve her in, our kids' lives and what they're doing here. And the person or people, whoever it is that took this and it actually made it kind of sick because it's summertime. They're my kids. CPS worker, she showed up and told me the trampoline is in my backyard. It's not exposed to the road. I was the only person home. She never seen any reason that it should have been explored any further. Matter of fact, she told me stories about her son running around naked till the age of 4. And then the other charges that were brought up were I was forcing my daughter to sleep in my bed. And that is completely false. And the CPS worker found out that it was false. After she interviewed my daughter, she found out that the only place my daughters sleep are on a mattress, a king size mattress that I carry into my living room. Usually on the weekends that I have them, put it on the floor in the living room. I sleep on the couch or in my bed. The kids either sleep in their own rooms or they sleep out there. We have popcorn and movie night. The CPS worker told me that's exactly what Demi told her. And my story matched up identical to what Demi said. Whoever's doing this, and I have a feeling it is my oldest daughter, Mrs. Weck has been misguiding my oldest daughter, one of my older daughters in this case for a while. And it's getting to a point where I feel I got to carry a body camera on me anytime I have my kids, because Mrs. Weck will take any little tiny thing I might not do perfect and try to turn it into what this is. Every time. This is not the first time I've been in court or had to have a hearing dealing with these situations. And it's hard because my kids they're taking it hard. They're not having the parenting time that they want with me because I feel like I can't. I feel like I can't even hug my kids without feeling like I'm doing something wrong. It's getting ridiculous. I did order like I said, from CPS, the order, but it's goes through a bunch of paperwork, she said. And once I find it, I get it. I'll address. I'll probably seek other avenues after I find out what's going on. But I'm to the point where it's so scary to get my kids. Mrs. Weck is not friendly to me whatsoever. She does not give me a second longer with my kids at any point in time. I asked for, can you do something for me? Or, can we pick up, like yesterday, I asked if she could pick up my kids from the house so that I could spend a few more minutes with them. It's actually closer for her to come to my house and grab them. And I understand it. If that's where she wants to go, to McDonald's, I just was reaching out to her, trying to make amends. I need her to be friendly to me, and I need to be friendly to her. And our kids are actually really suffering from this, sir. I can't stress it enough. I talk to my daughters. I let them know that I'm always here. They need me. Mrs. Weck will not let them call me at all, ever. I did supply my daughter with a phone, and Miss Weck has still got it to this day, will not return me my phone. She said there was evidence on it that she needed. Miss Weck still has not returned that phone to me, and I've actually ended up purchasing another phone for my daughter because I told her they could have one. And when I gave it to Mrs. Weck, she allowed it to happen. I was in Idaho elk hunting on a hunting trip, and gave it to my kids so they could continue to talk to me whenever they needed to or reach out to me. And Mrs. Weck, on the very first day, told me that she's blocking me. I'm not allowed to talk to my kids. I went 2 weeks without even being able to talk to my kids at that point. This is before it all got involved with Brenda the court. So it's been a battle every single time with my kids. I don't understand why I couldn't pick up my kids Friday. She had to work. That Friday was a day off. That Monday was a day off. I don't understand how this has to be so hard on us and the kids.
All right. This time, based on the evidence presented, I would find Ms. Wick in contempt for violation of the order on those two occasions. With the explanation, there would be an order directing the parties to comply with court orders hereafter, and Mr. Shelton would be granted 12 hours of makeup parenting time. Can you guys figure out when that 12 hours will occur?
Yes,
I would like to do it this next weekend if I could, please.
This next weekend, so this next weekend is not your weekend?
No, I just had them this weekend, and I'd like them the following weekend, if I could, please. It's their spring break. For 12, how come it's 12 hours? I missed a whole over the weekend. I got a Saturday.
My understanding, you missed the day on Friday, and then you missed Wednesday after school till 7 p.m.
I missed Friday, Saturday, and Sunday.
Oh, you missed the whole weekend?
She took the whole weekend from me.
Oh, okay.
And sir, that's what I was trying to explain was he missed from Friday until Sunday at 7 p.m. That's what I was trying to explain at the beginning. And I am fully aware of that. I would like 7 days of writing if we can do that. I know, does that comply with the court, or does just putting it here in this hearing that's
it'll be an order.
I mean, that's fine. He can have this weekend, the 25th, or I think it's the 25th.
Okay.
That's fine. He can have this weekend. My next question is, outside of this court or outside of this topic is, how do we enforce support? Do I have to file something to enforce support? Right now, he's $4,500 behind in child support. And then, he's also harassing via the parenting time app, and he's been calling me at 3 a.m. So do I handle that?
Yeah, I can only deal with the issues that are properly raised for today. If you have an issue with child support, you can contact your support enforcement worker. If there are other things you want addressed, you can file a motion or complaint if you wish.
Sir, I'm actually in the process of refinancing my house, and as soon as I get that up, okay.
And I dealt with the issue that was up for today. You'll have this coming weekend, this whole weekend, as makeup parenting time.
How about that Monday too?
Times that are normally in the order for weekend exchanges.
Thank you.
Can I have that? She also owes me a Wednesday. Can I have that Monday, that following Monday too? Because they're out of school. Can we just roll that Wednesday?
No, I don't agree to that only because you can have next Wednesday, which is typically spring break. So I agree to this weekend as your makeup weekend, and then next Wednesday as your makeup Wednesday for the dinner time.
Next Wednesday, there's in school.
No, next Wednesday they are in next week, which is 10 days from now. They're on spring break, which is my spring break. So I agree to this weekend, which is the 25th, the weekend of the 25th. And then the following Wednesday, which is my spring break, he can have them for dinner time, which is the makeup for Wednesday. I agree to that.
So the spring break would normally supersede the Wednesday parenting time because we don't want to have people if they go out of town come back for the evening parenting time. So that would be the makeup then would be next weekend, which is not normally yours, would be the makeup for the weekend, and then the Wednesday that you would not ordinarily be entitled to because of spring break, you would have that as well as makeup Wednesday.
Okay, that sounds great.
All right, we're all set then. You can order the mail in a couple days.
Now we're gonna go to part 2. Does it get worse? I didn't see this. This is Mike. Sean said it gets worse. Mike Page
I actually had the lady sending it to me. It has to go through process. So they just came to my house the other day, and I found out what they were trying, or whoever filed these this, what they were trying.
I totally feel like I need counseling after this one. Oh my god, and a tetanus shot.
And was pictures that I sent. It was actually a video of my daughters jumping on a trampoline in the summertime with the sprinklers on. They had soap, took Dawn dish soap and put it all over the bottom of the trampoline and was jumping all over, slipping and sliding and having fun. I did take the video and send it to Mrs. Weck, and I said, look, I can't keep clothes on them here either. Because prior to the day of this, my Tiffany FaceTimed me and Mrs. Weck FaceTimed me while my kids were jumping in and out of a water trough naked.
What?
And so, you know, we were getting along at the time. We were actually being kind of cordial to one another. I was trying to involve her in, you know, our kids' lives and what they're doing here. And the person or people, whoever it is that took this and actually made it kind of sick because it's summertime. My
I
kid,
didn't listen to
CPS
that one.
worker.
Hold on, I'm sorry. I'll do it.
She showed up and
I got you, Sean.
told me it's
where am I going, Sean?
The trampoline.
I didn't see this.
Charges that were brought up where I was forcing my daughter to sleep in my bed, and that is, they're not having the parenting time that they want with me because I feel like I can't. I feel like I can't even hug my kids without feeling like I'm doing something wrong. It's getting ridiculous. I did order like I said, from CPS, the order, but it's goes through a bunch of paperwork, she said. And once I find it, I get it, I'll address. I don't understand why I couldn't pick up my kids Friday. She had to work.
Can you guys figure out when that 12 hours will occur?
Yes, we can.
I would like to do it this next weekend.
The whole weekend?
Yeah,
she took the whole weekend from me.
Hold on. Hold on, guys. Sorry about that.
All right. Can you both hear me?
Hey, there's in school.
No, next Wednesday they are in next week.
Not ordinarily be entitled to because of spring break. You would have that as well as makeup Wednesday.
Okay, that sounds great.
All right, we're all set then. You can order the meal in a couple days.
So that was it. Oh, I thought there was more. All right, guys. I hope you had fun. It was crazy. Tomorrow I'll be right back at it, guys. That's it. You guys been absolutely served.